Dixon.
Thank you. Court recognizes that there is a Victims Impact Council pursuant to Marcy's Law. Sir, if you would enter your appearance as well.
John Lytle on behalf of one of the victims.
Thank you, Mr. Lytle. Mr. Dixon, would you please state your full name for the record? Spell your last name for me, please.
Devonte Dixon, Dixon.
Thank you, Mr. Dixon. Please have a seat if you would. We're here today for a sentencing on a plea that was taken on June 1st of this year. Has the state had the opportunity to review the pre-sentence investigation report?
Yes, Your Honor.
Do you have any amendments or corrections?
No, Your Honor.
Very well. Same question for the defense. Have you had the opportunity to review the pre-sentence investigation report?
Yes, sir.
Do you have any amendments or corrections?
There are two minor. One is as to jail credit. The other is to our client's place of birth. I will get to those in my statement.
Okay. Well, what is the jail time credit that you believe should be applied to this case?
445.
What is the state's position on 445 days of jail time credit?
We calculate the same, Your Honor.
All right, very well. Court recognizes 445 days of jail time credit and will hold your other amendment in reserve for your statements. We're going to have order in the court, please. From the state.
Thank you, Your Honor. Your Honor, I know this court has had an opportunity to review our sentencing memorandum. It is the state's request that this court impose a term that ensures this defendant remains in prison for the rest of his life. A few housekeeping matters, though, before we get there. First, Your Honor, note we had A through C in our memorandum. We have now provided the court a disc that contains exhibits A through F. Defense counsel does have a copy of those exhibits. I note that we have complied with Marcy's Law. And, Your Honor, at the conclusion of this hearing, court can expect the parties will probably submit an entry dealing with some property matters that we're still working on.
Very well.
Your Honor, as to the state's position, if the court would allow, I've got a little bit of media the state would like to play for the court at this time. Your Honor, those videos certainly offer but a glimpse into what transpired on May 28 of 2025. At this point, Your Honor, if the court will allow, Ms. Pritchard now has some comments. I'm going to put one more media document on the screen.
Very well. Ms. Pritchard.
Thank you, Your Honor.
And for the record, Your Honor, what's on the screen now has been contained in the state sentencing memorandum.
Court has reviewed it.
Your Honor, as the court can see, Officer 1 is lucky to be alive. What's striking in fashioning an appropriate sentence here is trying to accept a statement that there's remorse. These drawings, this drawing in particular, was found in the defendant's jail cell. This drawing teases, it taunts, it brags, it states, it ain't fun when I've got the gun. There's 2 badges hanging around this bunny's neck. Mifflin Township is written across a broken badge, and the date of this incident is on there. This drawing's offensive. This gives us a little glimpse into the mindset of the defendant. He was on community control at the time with a lengthy sentence hanging over his head. He evaded capture for 2 days, putting dozens of others in jeopardy. Law enforcement essentially stopping operations with dozens of agencies working around the clock to try to make sure that nobody else was hurt. And even when they did surround him in that apartment he was found in 2 days later, he still fired his weapon. He fired toward 4 deputies who were lucky not to be struck before he was taken into custody. So with these factors, Your Honor, a substantial sentence is definitely warranted here. This is the most serious and heinous of this sort of offense. Additionally, we'd like to thank the law enforcement officers who worked tirelessly on this case, and the victims and their representatives and family who have also put in substantial time and been patient and cooperative with us.
On behalf of the defense, Mr. Williams.
Your Honor, thank you, and may it please the court. Your Honor, I did review the same materials before today that the court did. I want to begin my comments by saying that anything that I offer here this morning is not an excuse. It's an explanation of how we got here. Nothing that I say is in any way going to attempt to minimize the harm that was caused by Mr. Dixon to these officers. Physical harm, emotional harm, psychological harm. We understand these officers and, frankly, their families have experienced that, all at the hands of Mr. Dixon. We own it. We understand. But nothing happens in a vacuum. There's a reason why things happen, and it's important for the court to know, it's important for the state to know, it's important for these victims to know, and it's important for this community to know how we got here. So social history is important. We put a great deal of emphasis in our sentencing memorandum on his history, not as an excuse, but as an explanation of why we are here. Whatever sentence that the court imposes in a few minutes, it's going to be heavy. If it's 30, it's heavy. If it's 90, it's heavy. Everything that he faces here today is mandatory time. He doesn't get days off for good behavior. He doesn't get any chance for early release. It's day for day for day. I first met Mr. Dixon August 1st, 2025. He had just come from Grant Hospital, where he endured multiple surgeries and was in a coma. He was transferred to a rehab hospital close to downtown. Me and Ms. Lawson went to visit him at the hospital. He looked pathetic. He couldn't talk. He had a trach in his throat. His only means of communication was writing on a whiteboard. I'm a career public defender. I didn't know what I was going to find when I walked in there that day. I have interviewed thousands of clients. I knew what the media had said about him. I knew what the allegations were. Went in, met with him. The first thing that he writes on his whiteboard, the only thing he could communicate on, was a whiteboard about the size of this page. And he wrote, "I almost took a father from his kids." I was relieved. I was relieved that he had humanity. He had heart for somebody else, not himself. It's very easy for criminal defendants sometimes to get very self-centered. That wasn't him. It was then that he started to realize the magnitude of the damage he had caused to these officers, to their families, and also to himself. On May 30th, 2025, that's the day he turned the gun on himself and was apprehended. It was his understanding, that moment, that he had killed one of these officers. And he had acquired a gun, it was a long gun, and was turning it on himself. He wanted to die. He couldn't face it. Nobody in this room can tell me that he's not remorseful. He didn't have a trial. Never wanted a trial. He knew what he did. He thought it best to plead to a series of charges and face the consequences, and that's exactly what he's doing. The fact that he accepted responsibility, pled guilty, should count for something. No one can tell me either that when he decided to plead guilty, there wasn't a whole lot of relief on this side of the room. There was. I want to talk a little bit about Mr. Dixon's life. He just turned 23 in June. He was born in Lima, Ohio. The PSI suggests Columbus, Ohio, but that's incorrect. Within the first 2 to 3 years, his mother and he moved to Columbus in hopes for a better life and more opportunities. I wish that happened. She did her best. She worked multiple jobs. He didn't have siblings in the household. It was just him. He recalls at age 5 having to move, and this is ironic, because of gun violence. Who in this room remembers age 5 moving because of gun violence? I would guess only him. Not what a person's memory of childhood should ever be. He was a decent student, C's, B's, and C's. He graduated from Northland High School. But in 2022, his life changed drastically. Within a month and a half, his 4-month-old child died of SIDS. And about a month and a half later, his mother passed away from cancer. He was devastated. That was his world. He spiraled. I think anybody in this room would have spiraled. Except most of us have support. He didn't. There's been a lot of talk about his 2023 case that he was on probation for. Acknowledge that that was a serious case. I wasn't part of that case, but there was a plea negotiation. The state of Ohio, the same office that's represented by these folks over here, joined in, agreed to a sentence of probation. True, the court always has the option to either accept or deny plea negotiation. But for the most part, the judges trust us. We know our clients, they know their victims, we know what's best, what we believe is best. So all of this criticism that he shouldn't have been out to start with is unfounded. Part of that probation, he went to CVCF. That is a lockdown facility. He graduated. That's not always the case. He was very proud of how he was doing. I believe it was about a year and 2 months after being placed on probation, takes us to the end of May of 2025 when this incident occurred. Obviously, on May 28th, you've seen the video. I've seen it more times than I can count. It's disturbing. We would show our client at the jail, he could barely watch it. He hates it. He hates what he did. It started, I would call it a garden variety traffic stop. Nothing crazy going on. He's a passenger in a car. So I would, among other things, disagree with Mr. Lytle about the other cases that we cited in our sentencing memo. Those cases all involve a criminal suspect starting the affray with the officers. That wasn't the case here. He was a passenger in a car that was stopped because somebody was leaning into it in the middle of a roadway. I'm not saying they should have stopped him or them. And he certainly should have stayed in that car, but he didn't start it. One of the important things in that video is he tripping and falling. I think that's when everything went south. I mean, it was already south, but it was even further south. Because at that moment, given his perspective, given his fear, he thought he was going to get shot. He reacts, jumps up, and starts firing. We've all seen it. He panicked out of fear. He reacted out of fear, not malice. The time between May 28th and May 30th, when he was on the run, he was literally going from house to house to house, trying to find anybody that would harbor him. He was exhausted. Nobody would let him stay. He was a vulnerability. As part of our investigation of this case, we had an investigator in my office interview my client's aunt. And I'm not going to use her name, much like the state's not using the officers' names. We interviewed her to verify what these SWAT officers had told her. SWAT was looking for Mr. Dixon, obviously, and showed up at the aunt's house, said that they, and I'm paraphrasing here, would shoot him on sight. We wanted to know whether aunt relayed that to Mr. Dixon. He had called her, of course, wanted to come by. She said, no way. And she relayed to him that they said they would shoot you on sight. For a man who is already afraid of the police, that's not going to make you make better decisions. He just got further deeper into this. He never contemplated leaving town. I probably have asked him five times at the jail if he ever thought of just leaving town. Never. There was this disguise, not his idea. Of course, he went along with it, not his idea. So that gets us to May 30th. Had another firearm. This time it was a long gun. He ends up in the Obetz area, crawls into this attic. It's like a 3-story apartment building with an attic at the top, an attic with no windows. He could hear the deputies outside. He knew he was trapped. He knew he was going to die. He believed he was going to die from these officers. So he turned the gun on himself. Before that, he prayed out loud for 3 to 5 minutes and turned the gun on himself, striking himself in the facial area. The whole SWAT incident at the Obetz address started at 8:02 p.m. and was over at 8:16 p.m., 14 minutes in length. Some of these shots that he was doing toward himself obviously went through the roof. I do not believe, given what I know about the discovery, the videos, and in conversations with my client, that he was shooting at any of those officers. I reviewed body-worn cam footage of those officers at Obetz. They're standing around. They are. I've had a cop shooting case before. It didn't seem like that. It wasn't casual, but it wasn't. I think they knew where he was generally in the attic. One of the officers said, quote, "Shots fired in the attic," end quote. So that helps us understand that he was in the attic. Next quote, quote, "He took one to the head. It took him 4 or 5 tries." Understanding that he was likely trying to kill himself. Last quote, and this one's a good one. "It's usually just one shot. He probably had to work up the courage." To me, they all understood he was up there trying to kill himself, not shoot at them. Did bullets leave the roof? Yes, they did. Because of that, we are asking that counts 6, 7, 8, and 9 be ranked concurrently to each other. In looking at the PSI, Your Honor, obviously we corrected the jail time credit on page 10. He does, one of the first 2 things I do when I look at a PSI is look at the offender's version. He does take responsibility, says he shot out of fear of the police. In looking at his record, he has only as far as juvenile record goes, a traffic case, no delinquencies, if you will. As an adult, there was a felony CCW reduced to a misdemeanor level offense in 2022, an obstructing official business felony. That was an incident that occurred when his child died of SIDS, and he was at the hospital. Is he proud of that moment? No. There were a couple of dismissed cases listed in the PSI. I'm troubled by PSIs including dismissed allegations. We can't have it both ways. The state can't dismiss a case, but then also hold you responsible for the allegation. And I know the court will put the appropriate amount of weight on a dismissed case. Page 23 in the PSI about his health. His health is poor. His health will always be poor, regardless of what the court does here today. He has permanent nerve damage and took some serious had some serious surgeries at Grant. It took months before he could actually talk to us clearly, and so I think health will always be poor. Page 24, finally, the other part that I look at oftentimes on PSI is his attitude. Felt shame and sorrow, and he wrote, I think, a fairly nice apology toward the bottom of that page 24. Looking at the state's sentencing memo, Your Honor, on page 6, the authors are opining, and as they did today, that Mr. Dixon has no remorse, no shame, no sorrow. We disagree 100%. What I have in my 30 years of doing this, what has always been very interesting to me is if a defendant in a PSI expresses zero remorse, then it's fair game for the state to comment about that. Of course. But when they offer that they're remorseful, the state will always say that this is self-serving. He's just doing it to get a lighter sentence. And so you can't have it both ways. The state wants it both ways. With respect to the drawing that was offered, I was over at the office this morning. I saw one of the reporters here in the room headline come across my watch, and it said something to the effect of "Shooter mocks Mifflin Township officers on the eve of sentencing," something to that effect. That is irresponsible to say that. They have no context of when that was drawn, for what reason. The sheriff's department took multiple drawings from our client. They gave the state 2. We spent some time in the sentencing memo addressing how these likely came about. He's in a single cell for a year, no counseling. The only people that will talk to him are standing right here. Is it challenging? Yes. Did it happen yesterday? No, it did not. Months ago. So it wasn't on the eve of sentencing. It wasn't to taunt these officers. He was expressing how he has been made to feel. I've kind of wrestled all weekend with how to address the victims' rights attorney's memo. I was disgusted when I read it. It's outrageous. It's undignified. It's unprofessional. It's disrespectful to this court. Lawyers using names like monster, animal, dog. This system and these 4 corners of this room deserve better. It was disappointing to read. My understanding of Marcy's Law is that, and I've rarely seen a Marcy's Law attorney, but My understanding of Marcy's Law is it's supposed to help victims be able to say how they feel. I really don't think that's what was in that. I think it's how Mr. Lytle feels. I don't think he did anything for that victim. I would be ashamed to have filed it. All that said, I understand and can appreciate the pain and suffering that the victims did go through, not minimizing that at all. Your Honor, briefly, we did file a sentencing memo. We put a lot of effort into that. And I think looking at the cases, the Ohm case from Union County, the Redmond case in Marion County, and the Jeffrey case in Allen County are illustrative of similar cases this year in Ohio. And like I said earlier, they were all cases where the defendant in those scenarios initiated the issue with the police. Mr. Dixon did not. It has become very clear to me, while representing Mr. Dixon, but also in general, you can't watch TV without seeing these types of incidents, Instagram, et cetera. You just see so much bad behavior that is toward the police, and oftentimes also police toward suspects or defendants. There is a large part of this population of young folks of color, who are scared to death of the police. Similarly, there's a large population of law enforcement that are scared to death of young folks of color. Until people start talking to each other, I hate to say it, but these kind of incidents will continue. Yesterday, myself and Ms. Lawson went down to meet with our client one last time, and I've asked multiple times at the jail when we're meeting with him, hey, what are the deputies saying to you? Because one of the unique things about this situation is he has been at the jail, and jail or deputies are for the victims of his case, right? So it's awkward, if you will. And I said, what have they said? You have sentencing tomorrow. What have they said? And he said a couple of deputies have stopped by and wished him well. In the time that he has been there, they have understood that he didn't have malice when he fired those shots. He panicked out of fear. That was powerful for me to hear. And I hope it's powerful for people in this room to hear as well. Nothing in law school, nothing in my 30 years of doing this prepares one as an attorney to stand in here and beg for a client's mercy. That's what we're doing. He's not a monster or an animal. He made a life-altering mistake out of a genuine fear. We are asking the court to consider, if not the minimum, something on the low end toward the minimum. That's all I have. Thank you.
Thank you, Mr. Williams. Mr. Dixon, this is your opportunity to address the court directly before I impose sentence. Now, you don't have to say anything if you don't want to, but you are welcome to, and sometimes it helps. If there's anything you want to say, this is the moment to do it, but you are to address the court and not anyone else in this courtroom. Do you understand, sir?
Your Honor, yes.
All right, very well. Please proceed, sir.
You'll have to address them.
Yep.
To the court. Okay. So I would like to take this time to just offer not only my remorse, but I'm putting my condolences out there because we've all taken a loss of time, a loss of who we were. And this isn't just saying who we were for yesterday, today, but when you go through trauma, when you go through terrorizing experiences and life-going experiences, like you will never see yourself the same again. And I took it upon myself to share pain because I know what pain is. Losing a mother, losing a son, having fear of having my friends killed by police. Was I wrong? Yes, 100%. But with me being wrong, I take ownership to that because nowhere in no one's right mind should that happen. But where do we both come together as a country, a state, an economy, youth, a team to change the generational curse of who's scared of who? Did I want to shoot my gun? No. But did I think I was going to die? Yes. I've witnessed friends get killed. So what do I think being a young black man who has friends from the age of 14 to 18 all dead? I don't know nothing but protection from myself. Who can I call on when the same people we're supposed to call to protect us is killing us? At the end of the day, my condolences go out because I was wrong. And I 100% don't say anything I did was right. I own up to my wrongs. And I hope that as the time goes on, that at some point in time, my condolences will be recognized because I didn't do this to myself to escape. I did this to show I have a human heart. I didn't do this to look like, oh, he's trying to escape or get a lighter sentence. No, like, this is what real human senses, heart, love, touch, sense, like, all of this is playing a role in how we will all leave this courtroom today. And as for the families, the children, as for everybody that's sitting here in this courtroom, I hope that everyone in here is blessed to still be here. And I count that blessing every day because I spent my time recovering, not worried about myself, but worried about a man who has had to be there for his children because I'm a man who does not have a child, nor has a caregiver. And it struck my heart to know that I almost impacted another person's life who didn't deserve that. And I just take ownership, and my condolences go out for the fact that I know that this circumstance is going to be forever replayed. I can't change what I've done, but I can at least take ownership and acknowledge my wrong. And I hope that one day I could be seen as a different person. That's all, Your Honor.
Thank you, Mr. Dixon. It's natural for all parties to want to present this case in the context and against the backdrop of a broader societal discussion. But this court is not trying to fix every ill of society at once. This court is trying to address and provide accountability for what has happened here on these facts, in this matter. And on these facts, there is accountability that's required. The defendant, while on community control, acquired a gun that would have been illegal for anyone to own, but that was a firearm that he was not allowed to have firearms at all. He then changed the trajectories of the lives of two officers and their families. It is only a miracle of modern medicine that officer number one survived, and for no other reason. Defendant then certainly had opportunities to reflect on the actions that had happened, and he did not take accountability. He fled and tried to disguise himself and evade a police dragnet. He then acquired another gun and ultimately led to the events of May 30th. That's one side of this. There is another side of this, which is that the defendant has pled guilty, has acknowledged what he's done, both in terms of the sparing the officers, the victims that were involved here, the trauma of a trial, and sparing the resources of the community the burden of placing the defendant on that in that trial. It is very hard to reconcile that back half with the drawing, particularly the first of the two drawings, but also the second of the two drawings that the court has seen. That appears to be bragging or preparing a resume of credibility for the time that you are in the Ohio Department of Rehabilitation and Corrections. And it is hard to look at that and see that any change has happened in your reflection from the first moment until the moment that you're standing here in front of me. I struggle with that, and have struggled with that as I've considered how to sentence you. You know that the sentence that I impose will be day for day. You receive no possibility of early release whatsoever. All of the time that the court imposes, you will do each and every day of it. You know that there are 445 days of jail time credit. After you are released from prison, if you are ever released from prison, Ohio law would require that you be supervised for at least 2 years and perhaps as long as 5 years. That is called post-release control. It's what most people think of as parole. Now, during that time, if that time was ever to be applicable, if you violated their terms and conditions, the adult parole authority could send you back to prison for up to 9 months for any single violation, or up to 1/2 of your total sentence for all violations, and they could do it without ever coming to court or talking to an officer. And if you were to find yourself in the situation where you received that, you also would be in a position where if you picked up a new charge and were convicted of that new charge, the judge in the new case could also add an additional consecutive prison term of either 1 year, whatever time is left on the post-release control term, whichever is the greater the maximum. Those are advisements that I am duty-bound under Ohio law to give you. The circumstances of this case make it substantially less likely that those advisements will ever have any practical effect. Considering the purposes and principles of felony sentencing set forth in the Ohio Revised Code under Section 2929.11a, the overriding purposes are to punish the offender and protect the public from future crime by the offender and by others, but using the minimum sanctions that the court determines appropriate to accomplish those purposes, and without imposing an undue burden on state or local government resources. Now, as it relates to the counts, at the time that we took the plea, the court advised you that for the first of these counts, you will have an indefinite sentencing range rather than a flat number. And depending upon how you carry yourself, the expectation would be that in prison you would serve the lower of the two numbers in that range. But based on how you carry yourself in prison, the prison authorities themselves could stack additional time up to the maximum number of that range, which is 150% of the lower number. Additionally, throughout, there are firearm specifications, and by operation of law and by the agreement of the parties and the acknowledgement of the parties, I should say, at the time of sentencing, those firearms sentences must be consecutive to each other and will be served again. It's all mandatory time. As it relates to count 1, attempted murder, the court sentenced the defendant to an indefinite sentence of 11 to 16.5 years in the Ohio Department of Rehabilitation and Corrections, that time to be consecutive to a 7-year firearm specification and a 7-year repeat violent offender specification. As it relates to count 4, felonious assault, a felony of the first degree, the court sentenced the defendant to 11 years of incarceration in the Ohio Department of Rehabilitation and Corrections, that time by statute consecutive to 7 years on that firearm specification attached thereto. As to count 6, the court sentenced the defendant to 5 years of incarceration in the Ohio Department of Rehabilitation and Corrections, that time to be run consecutively to 3 years on that firearm specification attached to count 6. As it relates to count 7, felonious assault, the court sentenced the defendant to 5 years of incarceration in the Ohio Department of Rehabilitation and Corrections, that time consecutive to 1 year on that firearm specification. As it relates to count 8, the court sentenced the defendant to 5 years of incarceration in the Ohio Department of Rehabilitation and Corrections. There is no specifications attached to that count. And as to count 9, felonious assault, a felony of the first degree, the court sentenced the defendant to another 5 years, again with no firearm specification attached to that count, and no repeat violent offender specification. Now, the court sentences the defendant to consecutive sentences on the underlying offenses, which is to say the court makes these specific determinations necessary under Ohio law to rebut the presumption of concurrent terms set forth in Ohio Revised Code 2929.41a, finding that consecutive sentences are necessary to protect the public, to punish the offender. They're not disproportionate to the overall fine, and further find specifically both that under 2929.14c sub 4, the crimes were committed while the defendant was under sanction or under post-release control, and additionally that the harm is so great or unusual that a single term does not adequately reflect the seriousness of the conduct. The total sentence that the court is imposing here, again, day for day with no possibility of early release, is a 67 to 72 and a half year sentence. The court recognizes 445 days of jail time credit and has advised the defendant of a 2 to 5 year post-release control period in the event that that becomes a relevant data point. Mr. Dixon, I struggled with this sentence, sir. I want always for folks leaving this courtroom to know that there is the possibility of redemption for everybody, and you will have the possibility of redemption as well. We will have accountability for what has happened, but you will find or have the possibility to find redemption of your own. It will be in the Ohio Department of Rehabilitation and Corrections for the next 67 to 72 and a half years. Anything further for the good of the order from the state?
No, Your Honor. Thank you.
Thank you. From the defense?
No, sir.
All right, we stand at recess. I'll see counsel in chambers when you're done.